we are streaming. Please rise. Loudoun County Common Police Court is now in session. The Honorable Rocky A. Cost presiding.
Thank you. Be seated.
On the record, Your Honor.
Okay, this is case number 20 CR 228, State of Ohio versus Johnny L. Losey, present for the state, the prosecuting attorney and Collins, present Dennis Kerr. And are you Johnny L. Losey?
Yes, sir.
All right, Mr. Losey, you're charged with felonious assault and forfeiture classification, and the trial set for actually later this week. It indicated that this would be resolved, and we have that set today. And I have been presented here with a bill of information, waiver of prosecution by indictment, and an outward plea of guilty. Okay. So looking at this guilty plea, it indicates you're going to plead guilty to a different charge of bill of information, aggravated assault, as well as a forfeiture specification. With an agreement that there be community control support. Okay. Let me start with this plea of guilty, Mr. Losey. First of all, I have this document that has your name on it, your case number, and it says it's an outward plea of guilty, which I'll explain here in a minute. But this is a 3-page document, and on page 3 there are signature lines, and up here at the top of the page there's a sentence that says, I entered the plea voluntarily. There's a signature below that. It looks like Johnny L. Losey, that signature here I'm looking at.
Yes, sir.
All right, and when did you sign this document, Mr. Losey?
Thursday.
All right, and was it your attorney's office?
Yes, sir.
All right. Now, when you signed this, did you understand that it's an agreement to plead guilty under a special plea of guilty, and that means that there's not going to be a trial. The next step would be a sentencing.
Yes, sir.
And did Mr. Kirk explain all this to you, go over it with you, and read it to you, and explain all the terms in it before he signed it?
Yes, sir.
Did you feel that you've had enough time to fully consider this matter before making this decision?
Yes, sir.
And are you entering into this agreement to plead guilty under the Alford case voluntarily?
Yes, sir.
Okay. Now, currently you're charged with felonious assault, which is a second-degree felony, which carries a possible prison term between 2 and 8 years, with a possibility of an additional 50% after a person goes to prison that can be added to that by the parole court. Now, what I see in the bill of information or in the guilty plea form is proposed that you'll enter a plea of guilty to the charge of aggravated assault. You got that on there as count 3. That should be actually BOI. Yeah.
No, I filed the BOI like the same case.
Yeah.
So.
But it doesn't make it count 3 in the indictment, I'm saying. So
well, I put count 3 on there so it makes it easier. Like when I say dismiss count 1 and
I'll
things
put
like that.
preface BOI in. Alright, just to show that that's bill of information. Alright. So, aggravated assault is a 4th-degree felony. And that is 2 degrees less than what you're charged with right now. And under the current one, if you were convicted, you could go to prison, like I said, anywhere from 2 to 8 years was over by the judge, and up to 50% added on. So if it was an 8-year sentence, it could be 12. If it was a 2-year, it could be 3 to 7. Now, the aggravated assault is a 4th-degree felony, and it carries a potential sentence of between 6 and 18 months, as opposed to 2 to 8 years plus 50%. And then there's a fine available up to $5,000 with the malicious assault, will be a fine of up to $15,000. So that is the reduction with the proposed pleas. And you understand that?
Yes, sir.
And you're not facing any felony charges anywhere else, are you?
No, sir.
And you're not on felony probation control, community control, post-release control from any jurisdiction.
No, sir.
All right. Now, under the law, if you are convicted of a 4th-degree felony and sentenced to prison, then in addition, once you complete the prison term imposed by the court, the law provides that the adult parole authority could decide to put you in what's called post-release control supervision for a period of up to 3 years. And that means you'd be supervised by a parole officer in the terms that the parole authority sets, because the court's not involved with that. And if during that period of time they determine that you were failing to comply, then they can return you to prison, make you serve an additional period of up to, in this case, half of whatever term you serve for one or more violations. But if you commit a new felony, then in addition to whatever sentence the judge, the new felony case imposed upon you, that judge would also sentence you in this case for committing that crime while under post-release control to an additional period of 1 year, whatever time left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively sentence in the new case. You understand that?
Yes, sir.
Under the law, I'm not required to send you to prison for the crime of aggravated assault. Can put you under what's called community control, which means probation, which means you be supervised on a term set by the court up to 5 years by the probation department. And if during that period of time the probation department felt you were not complying with the rules, they would file a written notice of that with the court, serve a copy on you. You would be entitled to have a hearing on the matter and to have an attorney representation during that hearing. And if the outcome of the hearing was that you failed to comply, then at that time the court could revoke your community control and then send you to prison for 18 months and fine you the $5,000. You understand that?
Yes, sir.
All right. Now, the bill of information is the new charge. And let me explain, and I'm sure that your attorney wrote this with you, but I need to explain it for the record. Under the Constitution of Ohio, no one can be required to face a felony charge in this court until that charge has been considered by the grand jury and an indictment returned. And so that's what happened with the Pleas assault case. Your case was submitted to the grand jury, they returned an indictment. Now, the grand jury is a group of 9 citizens from this county who meet periodically, usually once a month, to hear evidence about allegations of crime in the community. And then they decide whether there's enough evidence to justify the case being filed in court or going forward. Probable cause, so to speak. And only 7 of the 9 have to vote to indict, because they don't make a decision whether you're guilty or innocent, it's just whether there's enough evidence there to justify the case moving forward. Now, that has not happened on the aggravated assault. And so, under the law, you can't be forced to come to court to testify, to plead or respond to this case until that happens, unless you agree to waive or give up your right to have the grand jury consider your case. Waive means to give up. And so, if you waive that right, then the prosecutor files what's called a bill of information. Bill of information basically is the same as an indictment. It just says, here's what the charge is, when it occurred, what the charge is, and the section number and so forth. And so, other than the fact that the grand jury voted on it and the indictment has to be signed by the foreperson in the grand jury, the bill of information is the same. And so, what's proposed is a bill of information of aggravated assault, and I have here the bill of information that reads that on or about June 12, 2020 in this county, while under the influence of sudden passion or in a sudden fit of rage, either of which is brought on by serious provocation occasioned by Brett Toll, that was reasonably sufficient to incite said Johnny L. Losey into using deadly force, you did knowingly cause or attempt to cause physical harm to That should be Brett Toll, we got two John Lewis. So I'll change that, that's all right, Mr. Kirk.
Yes, Your Honor.
All right. So, physical harm to Brett Toll by means of a deadly weapon or dangerous ordinance to win Ruger Mini 14 rifle, violation of section 2903.12A2 of the Higher Advice Code, aggravated assault, felony in fourth degree. So I made the change, they had your name in there by mistake, as to the person that was harmed, or attempted to be harmed. Now, as I said, that's fourth degree felony instead of second degree felony. And basically it says that you caused or attempted to cause physical harm to Mr. Cole because he had seriously provoked you and it caused you to have a sudden passion or sudden fit of rage, which was sufficient to incite someone like you to use deadly force. Still a crime, but it's a lesser offense. So, you understand that charge?
I think so, yes, sir.
Okay, and this is what you discussed with your attorney.
Yes.
Alright. Now, as I mentioned to you, you haven't been indicted on that. So if we were, in order to go forward with this, today, we have to have what's called a waiver of indictment. I have here another document, your name and case number that says waiver of prosecution by indictment. It says, I, Johnny L. Losey, having been informed by the court of all my constitutional rights, my right to be prosecuted by way of indictment and be represented by Dennis Kirk, attorney at law of Hillsborough, Ohio, do hereby freely and voluntarily waive prosecution by indictment, agree to proceed in this matter by bill of information. It has today's date on it and a signature on John Losey and Mr. Kirk. That's your signature there on this document. Yeah. So you understand that by signing this document, you're saying, I agree that we'll go ahead and go forward today on this charge of aggravated assault instead of police assault without having the grand jury consider it. Do you agree to that? Please speak up. Do you agree to that?
Yes, sir.
Okay, all right. All right, are you having a little trouble hearing?
Yes.
Okay, just remind me or hold your hand up, I'm not hearing, if you're not hearing me, okay?
Thank
Because
you.
I know with this here, it makes it a little bit more difficult just to, stream in front of you. All right, now, Mr. Losey, under the law, you also have a right to, well, actually, you've had this for 24 hours, haven't you? You've had it since last Thursday, so we had that, okay. All right, so, you did have this, last week when you signed this document, you should see the bill of information, correct?
Yes, sir.
Okay, gotcha, all right. So, do you understand that charge and what the state is saying you did, when, where, and how they alleged you did it?
Yes, I understand.
Okay. And you discussed the evidence in the case, the legal issues in the case, the charge, possible defense you try to raise at trial, possible outcomes of trial with your attorney.
Yes, sir.
Are you satisfied with his advice and competence?
Yes, sir.
Now, are you under the influence of any types of drugs or alcohol at this time?
No.
Do you take any prescription drugs?
Oh, yes, sir.
Anything that would interfere with your ability to understand what's going on or to understand what you're told or read or your ability to communicate?
No, sir.
All right, again, if you have any questions about anything, if there's anything I don't understand, just, raise your hand or speak up and interrupt me and we'll clear it up, okay?
Okay.
All right. Now, has anyone threatened you to make you plead guilty here today?
No.
Now, on page 2 here, there's some bold printing and underlining. I'm going to read that to you. It says, defendant will enter a plea, Alfred plead guilty, count 3 of the bill of information, and count 2 of the indictment. And that's the forfeiture specification to forfeit the weapon that was used.
Yes, sir.
And it says then, state defense jointly recommend community control, which is what we used to call probation.
Yes, sir.
And you agree to forfeit the weapon as outlined in count 2, and then the first count of the indictment will be dismissed. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to make you plead guilty here today?
No.
Now, do you hold any kind of a license or certification from any state agency for any kind of a profession or occupation?
No.
Right? Now, you have certain rights that you must understand before I can accept a plea of guilty from you. First, you have a right to have counsel. Mr. Kirk's been appointed to represent you. Now, he wasn't appointed simply to work the case out, but provide any defense that could be available to you under the law that you would like him to provide. So if you decide you don't want to plead guilty here, that you would rather defend against this and fight this case, including having a trial, he'll represent you and he'll provide that representation. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have the right to have a jury trial in this matter. That means that 12 people would be selected from a group of people that live in this county who would be summoned to come into court for jury duty under your trial date. After those 12 are selected, the evidence will be presented, they'd be instructed on the law by the judge, then they would decide whether the state proves your guilt by proof beyond a reasonable doubt, and that would have to be a unanimous verdict, meaning all 12 of those jurors have to agree on whether you're guilty or not. Now, if you decided you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive, which again means give up, in writing, the right to have a jury trial. Then you would have what's called a court bench trial, meaning that the judge would be the one who hear the evidence, and the judge would apply the law, and the judge would decide whether or not the state proves your guilt by proof beyond a reasonable doubt. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Losey, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means is the witnesses against you have to come into court and testify in front of you and your attorney and anyone else that may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Right, under the Constitution, you have the right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come into court to testify voluntarily, at your request there's a subpoena issue, that's a court order, and that makes those people come to court to be available to testify even if they don't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes, sir.
Right, now under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You have the right to make that decision on your own. And if you decide you're not going to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one is even allowed to talk about it except in one situation. That is, if there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider that for any purpose. You understand that?
Yes.
Under the Constitution, Mr. Losey, you're presumed innocent of any charge until proven guilty by the state of Ohio on all of the essential elements of that offense. So the burden of proof isn't on you to prove you're not guilty of the charge. The burden is upon the state to prove that you are. In fact, at trial, you're not even required to present any evidence. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
All right, now, you originally entered a plea of not guilty. Plea of not guilty denies the allegations in the indictment, denies you committed any crime, and that plea exercises or invokes all the rights that I just described for you. So you have all those rights as we stand here right now, or sit here right now. Now, normally when a person pleads guilty, that is the opposite of the not guilty plea. In the guilty plea, you admit everything that's alleged, you admit that it's a crime, and admit that you're the one who committed that crime. Now, there is a special plea of guilty that is permitted in some circumstances in which the person, the defendant, pleads guilty not because they're admitting that they're guilty, but because they are admitting that there is strong evidence that is that can be introduced against them in trial that makes it likely that they will be found guilty, even though they say they're not guilty. In other words, the evidence is such that you believe that the jury would probably believe that and convict you, even though you're maintaining that you're not guilty. And so in order to avoid the consequences of having to go to trial, when you say you're not guilty, and facing the conviction on a larger charge, a greater charge, one is assault, which again has a 2 to 8 year minimum plus 50% of whatever the minimum is as a possible maximum. So it could be, in this case, maximum 12 years. In order to avoid possibly being convicted and having that kind of sentence imposed, the law says that you can plead guilty without admitting you're guilty under a special ruling from the United States Supreme Court. It's called Alford versus North Carolina versus Alford, which is known as an Alford plea. That's what it says on your form. And so that plea just describes what I explained to you. You are going to plead guilty to a lesser charge to avoid going to trial, not because you say you're guilty, but because you, after consulting with your attorney, believe that there is sufficient evidence that a jury will convict you of a greater charge, even though you say you're not guilty. Now, do you understand that?
Yes, sir.
Have any questions about that?
No, I don't.
Okay. And are you being coerced or threatened in any way in making this decision to enter this Alford plea?
No, sir.
And are you entering the plea voluntarily while maintaining your innocence?
Yes, sir.
All right. Now, the Alford plea then will make that admission, like I said, and what will happen is the prosecutor will give me a statement, and I'll look at the bill particulars and the discovery and any other information that she would like to present to me. Then, if I agree that is strong evidence of guilt, then I will accept your guilty plea. And so, in that situation, your guilty plea will waive or give up all the rights I just explained for you this morning, except the right to have an attorney, because you always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty will waive or give up your right to have a jury or court trial. It will waive or give up the right to cross-examine the witnesses against you in open court by your attorney. It will waive or give up your right to use the power of the court to compel or force witnesses to be in court to testify for you like the state. It will waive or give up your privilege against self-determination because you're admitting to that you're admitting for purposes of trial that you would be convicted. And then it will waive or give up your right to require the state to prove your guilt at trial by proof beyond reasonable doubt because you're pleading guilty, so they don't have to prove you're guilty other than what they have to say here today. It also waives or gives up any right to file an appeal you think you could have had up to this point in the case. If I were to sentence you to the maximum sentence, under certain circumstances, you can file an appeal. That appeal would have to be filed within 30 days of the sentencing entry being filed. Now, do you understand that?
Yes, sir.
Okay. The one thing I want to explain to you, Mr. Losey, is under the law, the matter of sentencing is reserved to the judge, not the parties. So even though the state and your attorney and you are saying that you should be given community control or probation, once I've heard all the information submitted about your case and you, I'm not required to follow that, so I could decide that you should be given a prison sentence of somewhere between 6 and 18 months instead of community control or probation. Do you understand that?
Yes, sir.
Now, do you have any, are you a U.S. citizen, by the way?
I'm sorry.
Are you a U.S. citizen?
Oh, yes.
Okay. All right. Now, do you have any questions at all about the Alford plea or what it will mean?
No, I don't believe so.
You have any questions about the new charge and the bill of information or count 2, which is the forfeiture specification of the weapon?
No, sir.
You understand both of those and the consequences? Okay. Do you have any questions about the plea agreement?
No.
Do you understand it?
Yes.
Have any questions about the constitutional rights I've explained to you today?
No, don't
You
have
understand
any questions
those?
at all.
Okay, you understand those then?
Yes, sir.
All right. Is there anything you need to speak to Mr. Kirk about before we go any further?
No.
Do you have any questions about anything that I've explained to you here today?
No, sir, not at all.
All right, then at this time I'll call on the state to provide the information. There is a bill of information, but in terms of the evidence in support of finding on the bill of information, set that forth, Mrs. Collins.
So I first want to say that this has been a case where I think Mr. Kirk would agree that rounding up the witnesses has been difficult.
We had to wait until some witnesses were actually in jail before we could interview them, so we do appreciate the court taking this plea at last minute. But I think that this case definitely is appropriate as an aggravated assault. Basically, the Reader's Digest version of events on June 12, 2020 is that Brett Toll and Samantha Crum are in a relationship of some sort. They are also cousins. Mr. Losey is Samantha
You should
Crum's.
call that kissing cousins. Go ahead.
Well, again, this is a situation where it depends on which witness you ask
Okay.
about the relationship. But Mr. Losey is Samantha Crum's stepfather and does not approve of whatever type of relationship this is. Mr. Losey was drinking that day, and Samantha Crum comes to his home. Now, there's a differing of statements at this point. Mr. Losey says that Samantha was saying that Brett was being mean to her. Samantha and Brett both deny that. But regardless, Samantha is in Mr. Losey's home. And quite a bit of time passes. At that point, Brett leaves the camper. There's a camper on the property that Brett and Samantha stay in, on Mr. Losey's property. He leaves the camper and comes up to the house. I think all parties agree that he at least knocked on the front door, and Losey told him to get away from the house, not to come in. At this point, again, versions differ. Mr. Losey states that Brett broke the screen door. Brett and Samantha both deny that happening. Samantha advises that Mr. Losey said if he comes in the house or if he doesn't leave right now, I'm going to shoot him. At this point, Mr. Losey comes to the front door, opens the front door, has a gun in his hand. Brett is not on the porch anymore. He's in the yard. There's no question about that. Mr. Losey shoots him in the leg with a .223. And Samantha at that point leaves the house as she had a warrant for her arrest. And so her version of events, which matches Mr. Toll's version of events, doesn't come out until later. I think the only discrepancy at this point is where Mr. Losey was standing when he actually shot Brett. He advises he was in his house. However, everyone, Samantha and Brett both advised he was not in the house any longer. And the spent shell casing was found about 20 feet from the front door, which would indicate that he was not in the house at that point. Regardless, Mr. Losey and Brett, there had been disagreements between them in the past, and this has been kind of a boiling situation. I think the violence was added to by the amount of alcohol that was consumed that day. And so based on all of that, the fact that Mr. Losey told Brett, leave my house, leave my porch, he didn't do that. He continued to try to knock on the door and get in the house and make a ruckus. We feel that the charge that is actually being pled to is the appropriate charge in this case. Thank you.
Sure. Agree with that presentation.
Do agree with those facts. With the bill of particulars did indicate it was about spent shell casing about 4 feet from the front porch, but there's no dispute by my client that he did in fact shoot Mr. Toll based on those facts.
And he's admitting that he was under strong provocation at that time.
That's correct, Your Honor.
All right. All right, then, Mr. Losey, is it your decision then to go forward and plead guilty to the charge of aggravated assault as you just further described in the bill of information?
Yes, sir.
All right, then, as to the charge which alleges, in honor or about June 12, 2020, Miami County, Ohio, under the influence of sudden passion or a sudden fit of rage, either of which is brought on by serious provocation occasioned by Brett Toll, that was reasonably sufficient to incite to send Johnny L. Losey into using deadly force, did knowingly cause or attempt to cause physical harm to Brett Toll by means of a deadly weapon or dangerous ordinance, to wit a Ruger Mini 14 rifle in violation of section 29.3.12 A2 of the Ohio Revised Code, aggravated assault, felony 4th degree, current possible prison term between 6 and 18 months, with fine of $5,000. How do you plead? How do you plead?
Plead guilty, I guess.
All right. Plead yes or you're sure?
Yeah, I'm sure.
Okay. Then count 2. That on or about June 12, 2020, in Highland County, Ohio, you had in your possession a Storm Ruger and Company Ruger Mini 14 223, serial number 18293-437, subject to forfeiture due to its instrumentality in the commission of facilitation of the offense, as defined in section 2941.14.17, which is simply to forfeit the weapon because it was used in the commission of the crime. No other penalty. How do you plead?
Guilty.
Okay, thank you. Be seated. Be seated. All right, the court finds that on this day, the court defendant was advised of all his constitutional rights, made a knowing and intelligent voluntary waiver of the same pursuant to Article 11. The pleas accepted and ordered filed. The defendant is found guilty on his alpha plea of guilty. The court finds there substantial evidence and a strong indication of presumption of guilt based upon the bill of particulars as well as the statement made by the prosecutor and the defense concession of that. The court will order a pre-sentence investigation of the same bond. The matter will be set for sentencing on May the 5th at 9 a.m. Count 1 is dismissed. So you report down to the probation office immediately after court here today, and see how long you need to make an appointment for a pre-sentence report that you pled guilty. And then you don't have to be here this Thursday, obviously. And Mr. Craig, the bail there, will have you sign a statement or sign notice that sets forth your date of your sentencing and your time. So we'll see you then. All right. Anything further, counsel?
Thank you.
All right, thank you.
So, one of them would sign and then you can down to the probation department, let them know you got signed, he'll write that on that problem.
Please rise.
streaming sound and video, and we'll wait for you to
Okay. I'm on Zoom here. Okay, good.
okay, we are on record.
Hey, Bill, can you hear me? You're gonna be appointed to represent Drew McGarry. You were appointed at the municipal court level. He apparently, he was high and apparently crazy the other day, so they didn't, we couldn't even arraign him because of the conditions in, so apparently he didn't understand what that meant.
Okay, you got them all
All
there.
right, are you, James Harold Schaefer?
Yes, sir.
All right, this is case number 18 CR 56. State of Ohio versus James Harold Schaefer. This is a hearing being conducted by Zoom due to COVID-19. Mr. Schaefer is appearing from the Justice Center. His attorney is William Armstrong. He's present. Also present is the prosecuting attorney, Andrew Collins. They represent the victim witness office observing, as well as the probation officer Ruth is also present. The defendant was convicted of burglary and theft and sentenced to a term of 36 months in prison originally. He was granted judicial release on the 27th of March of 19. There was a notification filed on January 25th alleging that the defendant had failed to comply with conditions set forth on the judicial release entry on March 27, 2019, and a supplemental entry filed on November 5th after a prior violation. That's November 5th, 2020. The violation was filed on the 25th. The court then notified Mr. Schaefer of that, I believe, on actually on the 1st of April, he was notified. Mr. Armstrong was appointed representative in the matter set for hearing today. Mr. Armstrong, you had an opportunity to review these allegations and consult with your client.
I have. I consulted with him yesterday, Your Honor, and he's indicated he's prepared to admit all of the violations that are alleged.
Okay. And you and me are waiving hearing in open court and agreeing to this hearing being conducted by Zoom.
Yes.
Okay, you're agreeing with that, Mr. Schaefer?
Yes, sir.
All right. Mr. Schaefer, the allegations against you that were filed on January 25th allege that you violated Rule 2, that you failed to report to probation since November 5, 2020. Rule 3, that on January 22nd of 2021, a home visit was conducted at the address listed on file and was advised by a male subject you no longer live there. Rule 13, that you failed to enroll and complete any recommended treatment program. And Rule 15, you failed to make any payments on fines and costs. And that was signed by the probation officer on the 25th of January. And then you were given a copy of that after you were taken into custody, I believe, on April 1st. You understand the allegations against you?
Yes, Your Honor.
I should note for the record, those were refiled on April 1st. After Mr. Schaefer was taken into custody, we originally set a matter for hearing. Okay. Now, you have a right to have a hearing in this matter, Mr. Schaefer, in which the state will have to present evidence that proves that you have failed to comply with these violations, or these conditions, so to say. You have a right to have your attorney cross-examine witnesses the state presents to bring out evidence to exercise the case. You have a right to present evidence on your own behalf and to testify on your behalf, although you're not required to do so. If you don't testify, it will not be used against you in any way. Now, In the event you should admit to the violations, I can do one of three things. I can continue judicial release, meaning control over the same conditions previously ordered. I can continue with additional conditions that I think are appropriate. The third, most serious, and I can revoke your free control, send you to prison, or send you back to prison to serve the remainder of your term. So, you understand all the allegations against you?
Yes, sir, Your Honor.
Do you understand the consequences if you admit to these violations?
Yes, Your Honor.
Has anyone threatened you in any way or promised you anything against you to admit to these violations?
No, sir, Your Honor.
Do you have any questions about the procedure or anything I explained to you?
No, sir, Your Honor.
I should have said this at the beginning, that if you would need to speak to Mr. Armentrout, since you're not present together, I can put you and him into a breakout room where just you and he will talk in a separate location on the internet. No one else will be hearing you or seeing you, and it will not be recorded. Do you understand that?
Yes, sir.
Do you feel you need to speak to them at all?
No, sir, Your Honor.
Right?
Your Honor, if I could I speak with Ms. Collins for just a moment?
There's no reason to do, we're not interested.
Okay, never mind, Your Honor.
Okay.
We were talking about.
All right. Then, Mr. Jackman, are you admitting to the allegations that I just read to you that were originally filed on the 21st of January and then refiled on April 1st, I think with the addition of the amount due on the court cost, which is 806?
Yes, sir.
You admit to each of those violations?
Yes, sir.
All right. All right. Anything from the state of probation regarding this position?
Your Honor, the state is of the, and I haven't spoken with probation, but the state is of the position that the defendant should be sent back to prison to serve the remainder of his time. I would note that while it was not alleged as a probation violation for some reason, he was ordered to pay $16,000 in restitution in this case, and he has not paid anything.
All right. Mr. Armentrout?
Your Honor, that's the first I heard of the 16,000. Obviously, he was ordered to pay, he should pay it. But we'd ask the court to consider placing him, continuing him on probation. This was not my case originally, but I reviewed the file, and I understand that he was sentenced. The court did release him early on judicial release to STAR, which he successfully completed. And I think did some aftercare and family recovery services, but don't believe that he did complete that. He's admitted that he has a reporter kept on probation advised of his current address. He indicates to me that at the time he was picked up, he was working for Tom Morgan, who, of course, probably owns a fencing company here in town, and had in the recent past regained custody of his 3 minor children who go to school here in Highland County. They're now living with his 80-year-old mother. I point out that there's no allegations of any new criminal activity. Part of what he was thinking, although wrongfully he underwent surgery, I may have the date wrong, but sometime around November of 20, and that he was placed on, legally placed on Percocets at that time, but I believe it did cause him additional problems once he was on that. We'd ask the court, even though this would be the third chance, depending on how you count, to continuing him on probation. I believe he does have a few words for the court.
Jason, anything you'd like to say?
Yes, sir. I mean, I totally apologize, sir, for not going to probation and not finishing on FRS. That was my fault. I should have continued. I mean, I would like to continue on going back to FRS and the granted for me, sir.
Well, you got released on November the 5th after you had a previous violation, and that's the last time probation saw you. Well, why did you not report as you were told to?
Well, when I went to surgery, I took hold of his valve and let him know that I was in the hospital and I was having a little bit of complications and stuff like that. And then I asked the doctor not to put me on no pain medicine because I was afraid to relapse. And that's exactly what happened. And I was scared that if I went to anybody know that, they put me on pain medicine, that he would violate me. But I didn't know that I was allowed to have stuff that was prescribed in this stuff. I did not know nothing like that.
I told you that when I sent you and I gave you community control. That's right in your entry. I told you that. I go over each one of those conditions. So you did know. So, and if you weren't listening to me, then that's your problem.
Yes, sir, I understand. But I will continue on the FRS, and I will finish it. I promise you, sir, I really will.
Anything else you'd like to say?
Yes, sir.
Well, Mr. Chapin, I don't believe you when you said you weren't aware of that, as I just said, it was in your entry, I told you about that. You could have called in, you say you were worried about being violated, well, here you are, violated. Plus, we tried to notify you in January, without arresting you, to bring you in, and couldn't get a hold of you because you were in parts unknown. Now, you picked up a job, I guess that's a good thing, but the problem is, you're just, this is the second time now that you've done nothing that you were told to do. And so, there's no reason for me to continue you on community control, because I gave you a break to let you out of prison in the first place. Gave you a break last November, and you walked out the door, and that's all of you. And here you are, we tried to bring you in January, to give you another chance to appear voluntarily, and because we couldn't find you, we had to issue a warrant for you, to bring you in. And, now you tell me, I'll do whatever you tell me, because where you last 2 times you've been here, you haven't. So,
The day that you released me, I went straight to probation and checked in.
well, the fact of the matter is that you haven't been doing what you're supposed to do. You made no payments on restitution, you made no payments on court costs, you didn't complete your program. So it's clear to me that you're not going to do anything that you're told to do. So it's a judgment on the court that you be and are hereby terminated from community control. You're not amenable. This is your second violation, and in fact, you did nothing after your release in November. So there's no reason to continue on community control. So you are ordered to return to prison, serve balance of your sentence. You have to pay kind of credit there for the reason why you've been in jail. So you'll be given credit for the time you spent in the county jail for these last 2 violations since then, which appear to be 26 days back in October 11th to the 5th of November of last year, and then 3 working days you've been arrested. So you get an additional 39 days of this jail time credit. Since you're released. Now, on completion of the prison term, because of your conviction, it's mandatory. You put under post-release control, supervision for 3 full years, and that will happen if you violate those conditions. And the APA will be able to return you to prison for up to 9 months for 1 violation, up to a maximum of half of your prison term, which is 18 months for all violations. But if you are convicted of a new felony, then in addition to whatever sentence the judge in new case imposed on you, that judge is also authorized to sentence you in this case to an additional period of 1 year, whatever time is left on that 3 years of post-release control, whichever is greater. And if that occurs, that will be served. And secondly, to the sentence in the new case. I'll also tell you that your restitution is still in effect as a part of your sentence. And even after you complete your prison term, if you fail to make payments on that, then that will be collected through various means. And if it's found that you have the ability to pay and refuse to pay, then the court could hold you in contempt and put you in jail until you pay. You'll also still be required to pay the court costs. All right, anything further with counsel?
Your Honor, was he given credit for his time in the STAR program previously?
Oh, thank you. Yeah, I'll add that too. How many days was that, Mr.
He has 97 days, Your Honor.
97 days for STAR and 39 days from in jail. Okay, thank you for that, Mr. Armstrong. All right, that completes that case. Ms. Collins, we're going to go ahead and bring Mr. McGarry, and Mr. Armstrong will be appointed to represent him since he represented him at the prelim, so we can do that now and not have that do a block period.
Who is it?
Drew McGarry. 21 CR 44.
Okay, changing. On the record, McGarry.
Okay, you Drew S. McGarry Jr.?
Yes, Your Honor.
Okay, Mr. McGarry is current by video from the Justice Center. Also appearing in this call is William Armstrong, who is appointed representative at the municipal court level, and the prosecutor is Anthony Collins. The grand jury indicted you, Mr. Gary, on April the 6th on a two charges, breaking and entering and theft. Breaking and entering is a 5th degree felony, and the theft is a 1st degree misdemeanor. And he was served as taking custody last Friday, I believe. Now, Mr. Gary, you are entitled to have counsel represent you in this matter. And if you can't afford to hire counsel, will be appointed, and I do have, well, there's on the statement here on their, financial disclosure form said you were hiring Mr. Armstrong. He was appointed to represent you in this court. Do you have the money to hire Mr. Armstrong?
Yes, Your Honor. I was released on before I was indicted, like a few days. And I was out there and I contacted Mr. Armachild's office to find out how much it would cost, but I had not got an answer back yet from him. So
well, are you working?
No, Your Honor.
Do you have any money in the bank?
Yes, Your Honor.
How much you got in the bank?
$600-700.
Okay, well, I don't know that Mr. Armstrong, that you can afford to hire him at that amount. So here's what I want you to do. I'm going to go ahead and find, you need to fill out this form because you're in jail right now, and $600 or $700 will not be enough to take care of that. So the court will appoint Mr. Armstrong to represent you. Now, Mr. Armstrong, you familiar with the case? I believe you represented him at the municipal court level. So, do you waive the reading of the indictment?
Yes.
And how does your client plead?
Not guilty, Your Honor.
All right. You apparently had a probation violation we picked up. Are you being held by Judge McCann for something other than this charge?
No, Your Honor.
All right. We'll set your first pre-trial in this matter for May the 5th.
Your Honor, I'm out that week.
Pardon me? Oh, you're out that week? All right. May the 19th at 1 p.m. Final pre-trial will be June the 9th at 1 p.m. And trial will be set for June the 24th at 8 a.m. All right, now on the matter of bond, what's the state's position?
I'm not sure if I understood him correctly, but did he say that he had gotten bond in this case?
Well, that's what I heard him say. I'm looking for that.
Because the last time that we checked, he was in jail. That's why we issued the warrant.
Okay, here I have an entry signed by Judge McKenna on March 22nd, OR only, on pending charges. And then,
Your Honor.
just be quiet, Mr. Gary. Look, I'm looking and reading here. And then he was granted, he had to serve 30 days from March the 2nd. It also said $10,000 in GMHA after serving 30 days on 20 CRB 289. Were you on electronic monitoring?
No, Your Honor. I finished all my time for Mr. McKenna.
All right, so where were you picked up then on this?
I turned myself in.
Okay. Yeah, because it says that the warrant was issued on the 6th of April after grand jury and, was executed on the 9th. And I know there was indication that, he was not in condition and he could be raised Friday, when they picked him up, so, apparently he was out on a bond, over on this, so, where are you living, Mr. McGarry?
I'm with my sister.
I said where, not with who. What is the address? What is it?
6611 Wizard of Oz Way, Hillsborough, Ohio.
And who is your sister?
Ashley Siders.
Okay. All right. Well, since it's a 5th degree felony, I know you have a prior record. I'm going to release on your own recognizance, which you promised to appear. And if you fail to appear, you could be prosecuted for additional felony. You'll have to pay a service fee of $171 deposit within 30 days. So since you said you had $600 or $700 in the bank, I would expect you to pay that by the end of the week at the clerk's office. You'll be under pretrial supervision and probation, so you report to them at 117 East Main Street, and you report to there once a week for 4 weeks. After that, as they determine under a random drug test and they order, provide phone numbers for home, self-employer, don't have contact with any of the alleged victims, Mays, in any way, shape, or form. If recommended by probation, you be evaluated for substance abuse, mental health issues, if treatment indicated, to roll in and follow that, while the case is pending. You also be under house arrest at your residence at 6611 Wizard of Oz Way, Hillsborough. Meaning you have to be there at all times unless you're working, going to and from work. Medical appointments, court proceedings, in this or any other case. Appointment with an attorney or probation officer for this or any other case. Attend any kind of school education training, and you may also attend church services. Other than that, you have to be there all times. If you fail to appear, or if you fail to comply, then the court will revoke that and hold you until further order of court. Also, before you're released, you must complete the financial disclosure form. And is the deputy there in the room with you?
Yes, Your Honor.
She heard that then, so they can have you fill it out. And then sign your order on there, go to probation today, and then if you're uptown, go to the bank, get the bank's uptown, get the $171 and take it to the clerk's office. Have any questions?
No, Your Honor.
All right, thank you.
Thank you.
All right, we have a notification, you don't need to be present for this, Ms. Collins, so a notification
Okay, thank you.
better.
On the record for Fender.
Okay.
I got video. Video. Right there now.
All right, we Molly, Aaron Bender.
Yes, sir.
All right, Ms. Bender is appearing by video from the Justice Center. Ms. Bender was convicted of aggravated possession of methamphetamine, a 5th degree felony, and was placed on community control on August 2nd, 2018. There was a notification that Ms. Bender had responded to supervision filed March 5th, March 2020, and March 6th, 2020, the court issued a warrant for her arrest, and apparently she was taken into custody over the weekend, and actually on the 10th, I guess, and there's investigation filed by the probation department, dated today, alleging that you have violated, several conditions of your community control, including, let me look at something here. There's 9/7/18, you put on community control. And August was the date of the plea. All right. So the allegation this offender is that you violated Rule 2 on or after 1/8/20, failed to report to the Huntington County Probation Department. Rule 3 on or after 1/8/20, made your whereabouts unknown. Rule 7 on or after 1/8/20, you consumed methamphetamine and amphetamines in buprenorphine, which is Suboxone. And Rule 14 is that on or about 1/8/20, you failed to complete residential treatment through Clean Acres. It was dated and signed by the probation officer, and it looks like you got a copy of it signed this morning, is that correct?
Yes, sir.
All right. All right, now, in the event you're found to have violated these conditions, the court can do one of three things. I can continue to control with the same conditions. I can continue it with additional conditions I think are appropriate, including extending the supervision to 3 years, or to 5 years. And the third and most serious is I can revoke your community control and sentence you to prison for up to 12 months and fine you $2,500. Now, you're entitled to have an attorney to represent you in this matter. If you cannot afford to hire one, the court will appoint one. So you have filled out a financial disclosure form, is everything on this form here. Please. Correct? Okay. When's the last time you were employed?
It's a few years, yeah.
All right.
I clean the house for a lady, I only do it like once a week, sometimes not even that, but it's not very much.
All right. The court then finds you're indigent. I'll appoint attorney Sarah Barger of Hillsborough, Ohio, to represent you. And we will set a hearing, evidentiary hearing on this matter for April the 22nd. At 1 o'clock. The week Thursday. We'll notify Ms. Barber of her appointment. And where were you arrested on this warrant, Ms. Bender?
In Brown County.
Okay. Well, you'll be held without bond at this time until the hearing. We'll notify Ms. Barber of her appointment. You also can give her a call to jail and get her number before you go there to jail. You have any questions?
Yes, sir.
All right, thank you. All right. That board does nothing until Wednesday on Zoom.
Okay, we're on the record.
Thank you. This is the case of State of Ohio versus Alicia Marie Ralston. Is case number 20 CR 257. Will counsel enter appearance, please?
Alan King, Assistant Prosecutor on behalf of the state.
Jake Wagner's attorney for the defendant, Your Honor.
Okay, we are here for sentencing. Sometime back, the defendant entered a guilty plea to complicity to escape felony of the third degree. Does the state have anything to offer?
Only what is contained in the plea agreement, Your Honor.
My memory of the plea agreement was that the state and the defense were going to recommend community control. Am I accurate?
That's correct, Your Honor.
Okay. Mr. Wagner, on behalf of the client.
Yes, sir, Your Honor, if I may. We would ask the court to follow the recommendation of the state. Normally when we have people, at least I do from my practice in community control, they go to counseling. I have the luxury of seeing them when they're arrested. They normally, if substance abuse is an issue, they normally look thin, emaciated, look bad, and I typically follow up with they look a lot better. Because of COVID, I never really got to see Alicia face to face. We do a lot through telecommunication, Zoom hearings. But she's been at the Georgia Harris House, one of our treatment facilities locally here, since December, about over 100 days. In talking here today, sad, it's an epidemic throughout southern Ohio. This is one of the longest stretches she's been clean in her adult life, Your Honor. But she's doing well. She's completed the inpatient residential. Her next phase would be transitional housing. She's here with a representative if the court does have any questions. But she looks good. She clear eyes. You don't see the typical telltale signs that we see for people on substance abuse issues. She sounds well. She sounds articulated today speaking with her. She looks forward, I believe, Your Honor, to completing her treatment, all aftercare. And I wish the best for her. I'd ask the court to continue her on community control and allow her to complete the Georgia Harris House program, Your Honor.
Thank you, Mr. Walston. Or excuse me, Mr. Wagner.
That's fine, sir.
Ms. Walston.
Yes.
Good morning.
Good morning.
You have a chance now to speak. You can sit. Just relax.
All right.
You have a chance now to speak to me if you want to. You don't have to speak if you choose not to. It's up to you.
I just want to say I would like to complete my treatment and move on to the transitional house.
Okay.
If you grant me that wish.
Thank you.
Thank you.
Okay, on the complicity to escape, which is a felony of the third degree, it is the sentence of court that you spend 18 months with the Ohio Department of Rehabilitation and Correction. That is suspended for 3 years of community control with basic supervision. There's no fine. You're going to pay the costs of this proceeding. I'm going to order that you work on your GED.
All right.
I'm going to order that you successfully complete the residential treatment at the Georgia Harris House, and that you then successfully complete any recommended aftercare. And that will all, of course, be supervised in the probation department. What is the jail time credit? I looked in the PSI, but not being loaded with the format of yours, I did not find it.
This is something that we had back April 6th, but it's saying 0 days.
Right. Your Honor, if I may.
Yes.
Typically, when the defendant's being placed on community control, the issue of jail time credit is not addressed. That usually does not come up until a later date. If and when the defendant may be revoked and sentenced to prison, then we worry about jail time credit at that time.
That is fine.
And I actually have a prepared entry for the court. I don't know if you, maybe you already have one. If you don't,
sure. Well,
if I may approach.
Yes, please do. Thank you, sir.
Mm-hmm.
Is it the habit here of the court to go through every one of these conditions on the record?
Yes, it is, Your Honor.
Then we shall begin. Okay, ma'am, you're to obey all federal, state, local laws. You're to conduct yourself in a law-abiding manner at all times. You're to report to your supervising officer as directed. You're to give truthful statements to all questions that are put to you. You shall keep your supervising officer advised of your residence and your any employment. You can't change residence without prior approval of the probation department. You shall not leave the state of Ohio without written permission. You shall not enter upon the grounds of any local, city, state, or federal correctional facility, nor communicate or attempt to communicate in any way with any inmate or prisoner in such facility without written permission from your supervising officer. You cannot purchase, possess, own, or have under your control any type of firearm, ammunition, dangerous ordnance. Defendant may not own or use or have in your possession any knives or tools with bladed edges. If this becomes necessary because of any job that you have, then you've got to get permission to have those implements from your supervising officer. Defendant shall not purchase, possess, use, or have under your control any type of controlled substance or drug of abuse, CBD oil, kratom, I don't even know what that is. Does anybody?
Synthetic, something new on the market, Your Honor.
Okay. Sorry, I'm not up with it. You're not to have any variant or any analog of any controlled substance that has effects similar to controlled substance or drug abuse. You're not to have any instrument, device, or thing that could be used to administer drugs or prepare them for use or administration, except for those which you have a lawful prescription. And you've got to let your supervising officer know about any prescription medication and get written approval of that. You're not to purchase, possess, or have under your control any type of alcoholic beverage or be in any present in any place where alcoholic beverages are sold or where they're being consumed. You are not to associate with any of your co-defendants in this case or with any other person who has a criminal record or members of a gang or other criminal group or any person who has in the past or could in the future influence you to commit a criminal offense or to violate any condition of your community control. The exception here would be is if you get approval in writing from your supervising officer. This includes family members, excluding those who reside with you or were residing with you prior to the commission of this crime. Defendant may not, after the date of this order, marry or establish a cohabitation in a common law marriage type relationship with another person without the written permission of your supervising officer. You shall report any conviction, arrest, or citation or other charge of violation of law or other contact with law enforcement no later than the next business day after that occurrence. Defendant shall provide the supervising officer with financial information records so that the ability to pay, in this case, your court costs and fees, you need to provide that so that the probation department can review those records. if the defendant's supervising officer or other probation department officer refers the defendant for evaluation or assessment in any type of treatment, therapy, counseling, training, or education program, if you comply with that, you shall submit to such in any type of that sort of treatment, therapy, counseling, training, or educational program that is recommended through the probation department. You'll successfully enroll and complete any recommended program. You're to pay a $50 per month fee to the clerk of the courts to be credited to the county supervision fund. What date should I enter here as the beginning of this? Today's date? Or?
If I'm 1 second.
I've heard it so many times.
I don't know that he's doing it.
Your Honor, typically, defense counsel or the state we do not prepare these entries. Off the top of my head, I don't think it's the practice of the court to order that monthly fee, but I would like to check.
I've heard it so many times, I can't recall.
Oh, go check.
Okay. We'll pull out the number 14.
Okay.
Yeah.
Get more info. As I indicated earlier, pay the court costs. That'll be regulations to the court. Defendant shall perform 400 hours of community service at a rate of 20 hours per week for 20 consecutive weeks, unless she is employed at least 20 hours per week, or is a full-time student, or is documented by a physician or prior disability finding physically unable to perform said service. I don't know what your availability is going to be with your in treatment, and then you go out into residential. But to the extent that you're able to do this, you're either going to find employment and be working, or you're going to be working in this community service. I'm not going to order any days in the Highland County Jail. I don't believe there's any restitution involved in this case. The special condition here that I mentioned earlier, you're going to successfully complete substance abuse treatment at the Georgia Harris House, and you will successfully complete any aftercare, and you're going to work toward your GED. By accepting these community control sanctions in this order, you shall be deemed to have consented to a search without a warrant of your person, residence, vehicle, or any other property or place that's under your control. So the probation department doesn't need to go to the court to get a warrant to search you or any place where you're located.
Okay.
There's no fine. There's no driver's rights suspension. I don't believe there's any mandatory fines in this case. As I indicated earlier, this is an 18-month sentence to the Ohio Department of Rehabilitation and Correction that is suspended for this community control. Ms. Ralston, you're going to be under supervision for 3 years. I hope all goes well, but I need to talk about if it doesn't go well, what could happen. You could end up back here in this courtroom, you'd be dealing with me. I would have options on what I could do. I could extend your period of community control out to 5 years, or I could put different or greater restrictions on your behavior, or I could revoke the community control and I could send you to prison for up to 18 months. Any questions about all of that? If you go to prison on this case, at the point where you are released from the prison, there would be a 3-year period of what is called post-release control. They would supervise your behavior out on the street. I believe this offense calls for a mandatory 3-year period.
That's correct.
So there's no option. They will supervise your behavior. If during that period of supervision out on the street, you violate any condition of your post-release control, they can send you back to the prison for up to 9 months for each violation. If there would be repeated violations, it could add up to 1/2 of the sentence. So in your case, your sentence would be 18 months. They can send you back for another 9 months, 1/2 of the 18. If you mess up every way you can turn this into a 27 months instead of 18 months. Understood?
Yeah.
There's some other sanctions that I need to explain to you. A violation of any post-release control rule or condition can result in a more restrictive sanction while the defendant is under post-release control. An increased duration of supervision or control up to the maximum term. Re-imprisonment, even though the defendant has served the entire stated prison term imposed upon them by the court for all offenses. If the defendant violates conditions of supervision while under post-release control, the parole board would return you to the prison. As I said, for up to 9 months for each violation. This could total up to 1/2 of your stated prison term. If the violation is a new felony, the defendant could receive a prison term of the greater of 1 year or the time remaining on post-release control, which will be required to be served consecutively to any other prison term imposed for the offense. Okay, is there anything else that the state believes you need to do to complete sentencing here?
No, Your Honor.
Mr. Wagner, anything?
No, sir.
Okay. Ms. Ralston, I am happy that you are doing well. Don't take this long. I hope I never see you again. Okay? Because if I do, it means you've messed up in some way that causes us to revisit all of these issues. So keep up the work that you are doing. I wish you all the luck in the world.
Thank you.
Folks, thank you.
Thank you, Ron. Hey, I wish you good luck, all right?
Thank you.